Session number 3 is Litigation Strategies for International Businesses. In this session, we are delving into the intricate world of how businesses from different corners of the globe navigate legal challenges. We have assembled an exceptional group of experts to dissect the complicated legal issues that international companies often encounter. And it is a pleasure to announce a beautiful addition to this panel, Hina Bhamblani. She will moderate our session number 3. With a wealth of experience and expertise, Ms. Bhamblani serves as the Executive Director and Managed Review Leader at Ernst & Young, contributing significantly to the field of GDS assurance forensics. And our esteemed panelists for this session include Saloni Tuteja, Head of Legal Surveyor Middle East, Julius Handler. Clap for Saloni Tuteja, please. Julius Handler, Associate, Morrison Forrester, London. Yvette Stiles, Special Counsel, Longton Legal, Australia. Robert Whitehead, International Arbitration and Litigation Lawyer, Hamdan Al-Samshi Lawyers and Legal Consultants, UAE. Dana Hamaide, Corporate Legal Counsel, Sharp Consumer Electronics, UAE. Galina Lyubsheva, Group Legal Counsel, Open Paid, Bulgaria. I hope I spoke the word correctly. Rabi Fakhri, Managing Owner, Fakhri Law Firm, Lebanon. And last but not the least, Ekta Rai, Independent Lawyer, India. And now, over to you, Hina. Thank you.
Thank you for those wonderful introductions. Hello and good afternoon, everyone. I am Hina Bhamblani. I have been an Indian lawyer by background. I'm currently based out of Mumbai, India, and I have been handling litigation management services for Ernst & Young out of India since the last 16 years now. It is an absolute pleasure to be here in Dubai. I came here just about yesterday, so it's an absolute pleasure to be here and thrilled to be moderating this panel with litigation experts from across the globe. I'm sure each one of these experts, no pressure at all, but I'm sure each one of these experts will add a lot of value and their varied experiences onto the table as we get started with these discussions. So with that, I will pass it on to the panelists for their introductions.
Hello, everyone. If you can see me behind this panel, my name is Julius Handler. I'll keep my introduction short because this is the second panel I've been on. I'm a litigator at US firm Morrison Forster's London office. I practice litigation, arbitration, also white-collar crime, and it's great to be here discussing this topic today.
Hi everyone, my name is Saloni Tuteja. I am head of legal for a French pharma company called Servier. I've been a healthcare lawyer for the last 8 years, and before that I was a private practitioner, much like my colleagues here. And it's fun doing either of the two, so I'm very excited to hear more about the exchanges here and contribute my bit.
Well, hello, my name is Rabi' Fakhri. I'm Lebanese. I'm the owner and manager of Fakhri Law Firm. So our law office is based in Lebanon, and we have a branch here in the UAE. And well, I'm a litigator. Thank you.
Hi, good afternoon, everybody. My name's Robert. I'm a partner at Hamdan Al-Shamsi Lawyers. I'm a registered DOFC court practitioner, UK qualified solicitor, and most of our work is DOFC court work and arbitration. It's lovely to meet everyone.
Good afternoon, my name is Everett Stiles. I'm a special counsel, Longton Legal, based primarily in Sydney, Australia, but I'm looking after Melbourne and Brisbane as well. My core practice is in complex dispute resolution and also class action work, as well as investigations in the insolvency space.
Hello everyone, my name is Nina Lubteva. I'm a group legal counsel of OpenPaid. This is banking. This is PSP providing banking as a services, embedded finance, payment services, and everything related to the payment institutions. And I'm also transactional lawyer with more than 10 years plus experience in the IT field of the complex digital solutions and everything related to the IT business.
Hi, I'm Ekta Rai. I am from New Delhi, India. I've been practicing as a litigator for the past 10 years. My expertise currently is in commercial litigation and arbitration. And I also look into money laundering also. Thank you.
So thank you for those, again, wonderful introductions from everyone. I know it's post-lunch. Some of us, I know all of us love the lunch that was provided. Some of us may be sleepy. So we are hoping for this to be an interactive session. As you can see, it's a pretty big panel with people and from different backgrounds and different geographies. So we are hoping that we make this session as interactive as possible. Feel free to chime in with your questions, with your comments as we have this discussion. So with that, I think we are good to get started with the first or the global question that anyone may have for a litigation practitioner, and that is, as lawyers or legal professionals, how do we ensure that we are preventing litigations while we serve our clients or while we work as an in-house counsel for the companies that we work for?
So,
Thank you. And I think that really is a crucial question. While we may call ourselves litigation lawyers, really we are dispute resolution lawyers, and hopefully for our clients, their disputes either never arise in the first place, or at least they at some point hopefully settle and don't go to court. I think there are a couple of things you can do to prevent litigation arising. And I think a key thing is assessing where litigation may arise so that you can take the appropriate risk management steps. And of course, how you do that will be bespoke to the business you operate, the markets you operate in, and what your business pressures look like. So what I would do is, and what I would advise clients is to do really proper litigation due diligence. Look at your business, assess the vulnerabilities, speak to the relevant people, the relevant business heads, functional heads, to see what the issues are. And then that's step one. You've been able to look at where could these disputes arise from. So it might be that there are certain contractors operating in certain geographies that may result in issues. It might be that you're exposing employees to certain issues in certain geographies where a dispute may arise. So that's kind of step one, is assessing the risk factors. And then the second part of that is, what risk prevention strategies can you put in place? Given where the litigation, the dispute may arise, what measures can we take to make sure that we have, for example, a very robust supplier code of conduct, business ethics, to ensure that everyone knows what they're doing and there are proper group-wide policies? What can we do to ensure that we're not dealing with certain counterparties where litigation may arise? How do we make sure that our contracts have robust dispute resolution mechanisms? Do we have an exclusive jurisdiction clause, for example, in favour of a particular court or forum? Do we want to go for arbitration? In which case, how do we reflect that in our contracts? I think ultimately it's quite, no one really wants to litigate, obviously, but there are steps you can do to help you identify that risk and then manage that risk if it comes up.
Saloni, would you?
Yeah, I'll just add Thanks, Julius. I think this was very, very comprehensive. Only thing I'll add here is also preparing your organization, and I'm saying it from in-house counsel perspective, is, as Julius said, no transaction, no third party can be risk-free. So first we have to embrace the idea there'll always be risk. Second thing is that risk analysis, as Julius mentioned. And then third is, or most important, is not only about third-party training, but how we train our people. We as in-house counsel or external counsel cannot be there everywhere. And unfortunately, usually we are few in numbers and the other teams are much larger in numbers. So I think it's important to have your hands and limbs and eyes and ears and sometimes mouths everywhere through your team members. It's training them, communicating how they should respond. For example, if it's a dawn raid, how do they respond if it's like a notice that they get? So that is also very important, which is a part of not only prevention but also management of dispute.
So Saloni, you brought a very interesting point about training and proper management or oversight of the people who do this. So do you suggest having specific training teams who lead these trainings and make sure everything is in place from an overall learning and development perspective for the team members on this front?
Yeah. So what we have done is, and I'm sure there are different perspectives and I would love to hear and learn from everyone here, is personally I have put a SOP in place on how to manage dispute. Even a termination is a termination of a third party or a contract, whatever it is a part of that policy or a SOP. In that, it's very strictly said, like if it's a termination, when to involve legal team, when it's not required to involve legal team, if you get a notice, if you get a investigation. So few permutation combinations we have put how to respond. If you have it, like I said, we can't be there everywhere. If you get a notice, then we have also put timeline, a RACI, about responsibility, accountability, all those things we have put. So it's like a guidance to them. Now, it's very easy to put a document and not do anything about it. So that's where I think training kicks in. And it's not a one-time training. You have to keep training people, because we as lawyers, whether in-house or external counsel, may put it very close to our heart. Oh God, we have a dispute. But honestly, business doesn't care. They just want to ensure that their business is not hampered, either right way or a wrong way. And I think I'm saying something which is controversial, but this is the truth, that they want their business to continue and not be hampered. So that's where your training comes in. That's where your relationship as an in-house counsel as well as an external counsel kicks in. How you manage people, how they come to you, have to also be very open. So, and not, if you start pinpointing the dispute is because of you, trust me, there'll be, and we have good sneezes happening here. And but get well soon. So all these things are a part of training or communication. Other thing is, if it's terminology, and I promise I'll just speak for another minute and hand over, is sometimes training communication seems little harsh words for team members. So it's better we say, exchanging of ideas, because the moment you say, it's a legal training, people will switch off their laptops or not attend the training. That's also again. So you have to be very mindful of the fact that people you're interacting will not be lawyers, or some of them will be lawyers and some of them are not, and they don't care as much. So your strategies on training, communication, being their best friend, it all depends on the environment and culture of your company and how you want your function to be perceived.
Yeah, I think there are some very good points which have been raised. So I'm a private practitioner, so slightly different view on it, and I think that might help a little bit, hopefully. So what we tend to do in private practice is we always look at the end game. So we will look at what we can achieve. So from an enforcement perspective, we will look at whether it's a viable target, whether the debtor is solvent, whether we can get the money, and how we can get the money, how quickly we can get the money, where the assets are. So in terms of risk, I think the key thing that we advise clients and focus on is the end goal, which is, it's great having a judgment, it's great having an award, be it in arbitration or be it in a DFC court case, but the key really is to make sure we get the money. So obviously with a legal spend, obviously we try and recover the legal costs. So in order to assess that, we do often try and get experts and even investigators where, you know, we legally can do involved at a very early stage, and then we can map out the claim early on and manage risk accordingly. Yeah.
As a private practitioner with over 13 years experience acting on both sides, the first important question that I have is understanding the client. What is it that they're trying to achieve? What are they aware of consciously or might not be aware of, to bring it to their attention, to understand and carve out the scope of work where I, as a practitioner, can deliver value to them. In Australia, the landscape is a well-regulated landscape with different states having different legislation, as well as a federal overriding centrepiece to guide that and those risks. So understanding the advice I'm giving in respect of my geography and how that connects, often with multinational companies, that involves understanding the structure of the subsidiaries and the parent company and what they're trying to achieve. It involves trying to get the right people together who are the decision makers to understand what their risk appetite is and the exposures are that they're concerned of. Any lawyer, in my view, can tell you what the black and white areas of the law are, what they should do and shouldn't do. But as litigators, on both sides of the table or the fence, our job is to navigate the grey. As plaintiffs, trying to make the grey seem so clear that you are able to persuade a judge, and as a defendant, to step that out and put that threshold of the onus of proof at such a level that it becomes complicated or difficult to deal with. Obviously, all of that comes at a price, and part of our mandate is to understand what budget we're working with, what exposures there are that are in play, to then cycle back to say, okay, well, we can deliver value to help you prevent these disputes. These are your current concerns. These are the list of priorities that you have, and build a long-term relationship with them where you are continually adding value to that relationship as a private litigator or advisor. Because as a private litigator and private practitioner, I know in-house counsel hate briefing me because of all the problems I'm going to pick apart and show them what they need to deal with. So there has to be a little bit of comfort and sensitivity around that, and that's about understanding the current landscape, what the current issues are, and the risks to business that you're advising on.
Hello, everyone. Today in this room, I was thinking my thoughts what I'm going to say is that actually, as an in-house legal counsel, I understand that my job is to preventing the company to pay to all of you here, maybe most of you here. So this is one of the litigation strategies in the in-house. Do not pay the money for the outside counsels. So because they are costing a lot. Your guys are costing a lot. So when we are talking about litigation strategies, it's actually how you're going to save money, because we are saving money from litigation. And this is the big strategy, what you are going to do to save the money, because you want not to spend this money for lawyers, you want to spend this money for the product knowledge, for the investments, for everything, what the scope of business is. And my work is to prevent the risk. What is the risk? I don't want to pay you guys, so I need to do my job really good. And how I need to do my job as a transactional lawyer? I need to focus what in the contract can cost money, where will be the disputes. So what I have to do, I'm going to product, talk with product. I'm going to finance, talk with finance. And I'm doing my job good. I'm adding dispute clauses to make sure that every governance process will be covered before we even start thinking about litigation. That's the first point. I'm thinking what will be the applicable law, whether it will be the civil law, whether it will be common law. So this is very big thinking when we are talking about litigation strategy. Are we going to have arbitration? Absolutely. if I'm going to have a dispute between common and civil, then I would prefer arbitration, of course. But this is depend. So yeah, when we're talking about, or at least for me as a transactional lawyer, when I'm thinking about litigation strategies is where there no be money leakage, because litigation is money leakage for the companies, and you don't want to do your job bad to company to be exposed on that risk. So this is how we are preventing litigation.
Well, one thing we don't want is to deal with a company that has a colleague like that. Yes, because I think I will pick up on what Julius said and what Yvette said, because as lawyers, especially when you're dealing with international businesses, the first step becomes dispute resolution indeed. What you are trying to do is pick apart whatever transaction you want to get into, understand what is the nature, like you start from the scratch, you understand what is the business about, what do you aim to get out of it. Then you understand, because it's international, in all likelihood there'll be cross-border transaction. What are the cultural differences? Where is the, most importantly, how do you handle litigation? How do you handle your conflicts? While we do have and while we do prefer having an ADR clause or, to try and make it more conducive to alternate dispute resolution mechanisms, not every dispute can be handled that way. So to keep all of those things in place and understand what are the potential problems that can arise for you is something that we have to look at. If we have a colleague like that, we are bound to change the ship, but all right. But the thing is, if it does come to the fact that you have to litigate, I believe that disclosing these things, are getting a clarity on what your end game is. Do you want to settle? I personally, I believe, and it has been my strategy for the 10 years, not to encourage litigation, counterproductive, but I think the best kind of litigation is to prevent it from lugging on. And if you can do that for a client that is coming from outside of the country, I believe you're building more stronger relationships, maybe a little more non-commercially sensible, but I think it in the long run pays. You develop a trust in your own system, you develop a trust in the manner you're capable of handling the client, and eventually I think better resolutions are found outside of the courts also. So that has to be my strategy, but I'll keep that in mind.
Sorry, just to add one more thing in terms of prevention and mitigation, for me sort of go hand in hand. And when you understand the client's business and what their exposures are, there are some opportunities for looking at how those can be insured, or underwriters that are able to cap off those exposures, D&O insurance, looking at PI, all those sort of elements. As a private practitioner, understanding what the gambit of those policies are and how they might apply might help me navigate those issues in terms of wondering what my war chest might be to defend or resist those claims, or different steps required to keep those premium downs within in-house counsel that can help prevent those risks in a meaningful way that helps the business save money.
Sorry, I'll just add one more thing, and I love the undercurrents between the in-house and the external counsel, because I've been both. I have been a dispute resolution lawyer for 9 years before I moved in-house, so I did change my ship. Having said that, I think it's all these aspects are very, very interesting. That's saving money. I think what is important is we don't spend good money for bad money. I think that should be the underlining. And also one more aspect that I'd like to add when we decide whether we want to go for a dispute resolution or not are also these softer topics. Sometimes it's not about money. Sometimes it's not about the end goal is, okay, I'm going to extract XYZ from somebody. It can be as simple as reputation, setting a precedent for your company and for your partners as well as your employees. So there are, in addition to this numbers and these harder, topics, I think softer topics are also very relevant for a company when they decide to go for a dispute. Another very interesting aspect, I think, Ekta, you brought it up, is about ADR. I remember till 6 years back, and maybe I was naive, a lot of people used to say, go blindly for alternate dispute resolution. Don't go for litigation. I think that was such a myopic view. ADR, alternate dispute resolution, does not work with every jurisdiction. It has to depend on the maturity of the country you are working in. Second is, which again I find it very naively said, that if you're, like I'm a French company, or I work for a French company, and if my company is in UAE and the other company is, for example, in Lebanon, blindly go for United Arab Emirates law. It's not like that. If your contract is related to human resource and the human resource is based in Lebanon, you cannot have a UAE law. It would not work. So you have to have the governing law based on the subject matter and your third party. It cannot be blindly, my company is in France, so it has to be French law, or my company is American, let's do Californian law or whatever law. So that's, again, I think you have to be very, very mindful of, and I think it's a part of prevention as well as management.
No, and just picking up from Saloni's earlier point, and I know Ekta and we've been discussing that, the discussion around in-house and outside counsel, the potential friction or hesitance to use one versus the other, I add a third element to it because I am a part of a team that provides managed review services, that's litigation managed services to clients across the globe. So the job of my team is to be an extension of the in-house counsel and the outside counsel who's representing the client in the court of law. It could be anywhere across the globe again. So I think that's an interesting discussion that has come about, but the way I would think about it is that the job of the in-house counsel, of the outside counsel, and any managed review vendor that's getting engaged during the process of the litigation or the investigation, the job is to ultimately do what is, as Saloni rightly said, based on the different criteria or factors that the client has in mind, is to ultimately do what's in the best interest of the client from a pricing perspective, and making sure that the right blend of people could be your in-house or outside counsel, the best people to do the job. It's the right balance of the right people, processes, and technology that are getting deployed in order to ultimately deliver what's in the best interest of that litigation. So
I agree with you, and I'm not adding anything else additional, except just saying that, jokes apart, I believe whether it is an in-house counsel or a litigator, the end goal, I believe that anything reaches an out-house counsel or a lawyer or an advocate is when an in-house counsel now needs backup. If we look at it like that, it's not exactly either or us against them. It's actually a team. It's just that there is one internal team. The internal team has found that they were either the contract is such that now they have to go for something. Like Saloni correctly said, not every issue can be addressed by an ADR system. You will have to deal with litigation sometime or the other depending on the nature of the contract. At that time, you will outsource that resource, right? That is where we come in. And when we are coming in, the idea is not to badger the in-house counsels with the fact that, oh, you did not do this, you did not look in. I am sure they did. I am sure if they're working to, with a company that is dealing with international conflicts, they did their job well. But the whole objective of having this particular line of defense is that you can never be 100% sure that a deal is going to crack without any risks involved. It is that risk mitigation that we do. We are simply putting up stairs. The baseline, the most strongest of defense in-house. You've prepared a draft that can't be challenged. You've made sure that where the law is governing, law has to be taken care of, you take care of that law. You make sure that the transactions, like you go to the finance, you go to the product, you say you fix this thing, or you're going to lose money. But what do you do in the case of the third party? There is a third party. You can only control yours. What about them? If they end up having either a competitive in-house counsel or an incompetitive one, it doesn't really matter. The ball will still fall, right? And that is when you call the backup. So I guess the out-house counsels are just backups. So picking apart this thing, we're basically a team. That is how it is.
Can I just add something here that you're absolutely true, and actually when we're talking about the defense, even the consulting with colleagues like you, it's in the very first stage as well. And I can give you example from the fintech and payment services industries that when you want to provide the services and want to open new markets, for example, Asia or South of America, you need to deal with local companies, let's say. And I will give you example from my experience working with deal in Brazil. So actually this is a very different legislation and how to say very interesting country to make business, especially from the legal perspective. And when you want to negotiate a deal with a bank there, be sure that they're going to push the legislation and the applicable law to be the Brazilian one. But you don't want to go to Brazilian courts. I'm not going to tell you why, because I'm sure that you guys know much better than me why you don't want to go there. And he's not here. He will be tomorrow. And I called Adrian Cole. He's on the arbitration expert, and I tell him, come on, give me the strategy about arbitration. I need to propose arbitration here. And we brainstormed for 30 minutes with him. He gave me 4 different strategies for arbitration. And guess what? One of these strategy actually works, and I was able to negotiate the contract with arbitration with for a lot of money, actually. But I mean, the scope of services was for a lot of money, but the arbitration was accepted by the business because the risk really was mitigated, and that was because me as in-house was absolutely, how to say, aware that I need to support, to go to see support from the outside, to prepare my strategy and to go and to run it. And actually that works. So one of the strategies to prevent litigation as in-house is to go to external one to give you the idea what you should do.
The only thing I'd like to add to that is that in private practice, obviously we've got solicitors, but we also sometimes go to external counsel as well. So we'll go, as I'm sure you're all aware, we'll go to barristers as well. For example, so we do the DFC court work. Our firm, myself and Hamdan, are the advocates, and we will do DFC court advocacy work. However, that being said, if there's a particularly complex trial of, say, 3 or 4 days and it needs that expertise, then we will go out and seek an external barrister, a KC, for example, in London, because the ultimate goal of any in-house team, any private practice team, is to win the case for the client. So again, I think we've said, it's about adding value for the client and it's about winning the case.
And if I could just add to that, the concept of what is winning is very different for different organizations, and truly understanding what winning means might have a different objective and goal depending on the situation and how to deal with it. And what I love as a private practitioner, having had both hats on as plaintiff and defendant investigations and dealing with litigation funding, in-house counsel, especially in multinational companies, who have their finger on the pulse as to what sort of disputes they're trying to be more cost-effective with, that they're trying to resolve, and the structures that they need based on data of their current spend on these issues, be it internal disputes, external disputes, disputes with certain clientele. That is when you can have a meaningful conversation that adds value, but also gives you a bit more of a generous budget when you look at those factors across jurisdictions to actually talk about what dispute resolution processes to suggest, how to encourage them at a front-end basis, or how to engage state courts or federal courts at various levels and adopt strategies to dealing with these by providing an overriding case theory. For example, class actions, having acted on both ends, there is a risk in being involved in those, but there's steps that can be taken by keeping that finger on the pulse of what those exposures are that help navigate or mitigate those issues, but also as an in-house counsel, show the board and from the board outwards that you care and you are taking steps to deal with those matters in a way which helps resolve disputes and keeps it out of court or keeps it out of arbitration. So you are reducing your costs. And my strong recommendation and encouragement to in-house counsel here who have the ability to track that data in different jurisdictions is to have that sense of collaboration with your counterparts in different jurisdictions to compare and talk about those issues, because the issues that we face, as I'm sure we'll find out this afternoon, are very similar. Our approaches might be different, our processes might be different, but these are disputes, some of which have to be resolved, but ultimately come at a cost to our clients if we're defending them, or at a cost to aggravate them.
So I see that we've covered a lot when it comes to prevention of litigation. Sorry. Yeah. No, I see we covered quite a bit when it comes to prevention of litigations and the whole distinction or the choices that have to be made between a litigation versus going in for an arbitration. Related to that, and I know Saloni touched quite a bit about it, that there are a lot of factors that have to be considered, factors like reputational risk, more recently given the focus on a lot of environmental issues, a lot of these additional or external factors that have to be considered. So what are your viewpoints on what, like, in order to get a holistic understanding or picture of how something should be proceeded with, what factors should be considered according to you?
So I think the first thing is to see what is stipulated in the relevant contract. It might be that there is an exclusive jurisdiction clause necessitating that any dispute that arises under a contract needs to be resolved in a certain forum or a certain state court. Might also make provisions for what the governing law of that dispute is. It might be that there is an arbitration agreement in the contract. That answer may sound a bit flippant. Just look at what the documents say. When negotiating the contracts and deciding what means of dispute resolution you go for, there are a number of factors you can think about. The first is, where is your business? In which geography do you want to be litigating? There may be some circumstances where you would much prefer to have arbitration. There are other geographies where you'd much rather have litigation. So that would be number one. And that requires consideration of where you are, where you want to litigate. The second consideration is a matter of confidentiality. Litigation is generally public, subject to certain exceptions, and arbitration is confidential. Third is the process and the mechanisms for how you manage and conduct the dispute. So, for example, if you choose to go through litigation in the English courts, you're bound by the English procedural rules. If you go for arbitration, ultimately you can determine the terms of engagement with the other side, subject to what the arbitral institutions' rules are. Typically, and as a general rule, arbitration lends itself to flexibility, which is both a good thing and a bad thing. I suppose it depends on the nature of the fight you're having with the other side. In a more collaborative dispute, actually, it can be very helpful to have that flexibility. If you're dealing with an adverse party that is seeking to frustrate and delay what happens, actually, sometimes you can think to yourself, I wish I had the rigour of a certain state court. But I think ultimately it depends on the dispute, on where you are, and just to underscore a really important point that Saloni mentioned earlier, the softer points. Are you dealing with something very commercially sensitive or areas that could really have a hit on your reputation? Are you dealing with potential regulator involvement, in which case you might want to have a more confidential forum in which you're litigating? Do you want there to be some kind of public precedent, or do you not want there to be a public precedent, in which case that might mitigate towards litigation or arbitration? And finally, where in the world are you having this dispute? Where's it arising from? But those would be, I suppose, from my perspective, having done both litigation and arbitration, what immediately come to mind when choosing between the two.
Thanks for sharing that perspective. One thing that Rabi and I were discussing before we started the discussion was, or is with regards to the use of international treaties as we proceed in the strategy of litigation. So would you like to share something on that?
Thank you. Yes, sometimes you have the relationship, the international relationship starts between two parties without even having a contract. So for example, in the trade of ceramics, people will buy ceramics from a country to another without having a particular contract. So you don't have the clause, you have nothing, you have just the trust, the commercial trust between both parties. And then all of a sudden the problems happen. And in these particular circumstances, where you can start the case is very limited. It's the place of the defendant or where the contract or the agreement have been passed. And the first strategy that for a litigator is to start